Ownership of drawings and copyrights. When a design professional creates a drawing or specifications, these are intellectual property rights that they obtain through the copyright rules and laws of the United States. These are federal copyright laws, and the architects and engineers who create these designs are the holders of these intellectual property rights. Oftentimes what you see in a contract is sometimes an owner will try to actually take possession or ask for the transfer of those intellectual property rights from the design professional to the owner. In these cases, this is actually something you would want to not do. The AIA has actually tried to create an instruments of service section of a contract that's been used for decades. Typically what happens is an architect or an engineer will provide a license to use the drawings. Then instead of providing the actual intellectual property rights to the owner or whoever they're in contract with. In this way, they still maintain the intellectual property rights, and they're providing a license to the user so that they can use it for this project. This is a good way of handling it, and it's the way that we recommend doing so. If you have a situation, though, where the owner is trying to take or wants to have possession of the actual intellectual property rights for the drawings, this could create some problems. One is that the owner or whoever is obtaining the intellectual property rights can actually use or reuse these drawings without your authorization. Unauthorized use of drawings is one of those things where you have no control over the owner's use of those drawings. They could be duplicated on other projects and potentially open yourself to risk that you did not expect to have. In that case, if you take, for example, the AIA form, they have included in the contract clause for the instruments of service a provision that if there's a reuse or an unauthorized use, that the owner will provide an indemnity and a hold harmless obligation for the architect in the situation where those drawings are being used without their authorization or being reused on another project where the design professional is not being asked to perform construction administration services or any services at all for another project that they were not retained for. The copyright and infringement enforcement actions are something that you have to be very concerned about because it's very difficult. I've actually been involved in some of those, and unfortunately you have to file those in federal court, and the infringement actions don't allow in most cases for the recovery of attorney's fees unless you've filed the actual drawings with the Copyright Office and submitted that prior to the lawsuit. Based on the foregoing, these are the most efficient ways to protect a design professional with regard to the ownership of drawings and copyrights. As I said, I think it's important that you do not give up the intellectual property rights, that you provide a license that has a contingency of payment being received first in order to receive the license. And finally, with regard to reuse or unauthorized use of the drawings, have the owner indemnify you and hold you harmless from any claims that might be related to the unauthorized use of the drawings. Indemnity in this case would be, for example, if a third party is suing you for the use of those drawings, then the owner would have to defend you and hold you harmless from that particular situation. This is a good way of having your contract protect you.